That's what I need to know. It sounds like we have a variety of experiences online. I'm going to talk about that form last. So the form is the template for a telephonic warrant, and that'll be the last thing that I talk about today. And it looks like we have quite a few people online who, there we go, who are in your rooms. So I got your messages. If you have more than one person listening in your room, you could send me a message to that effect. That would be helpful. Go ahead and start recording. Welcome to our last TSRP webinar on telephonic search warrants. We're going to go over the changes in the 2011 legislation that allowed us to get search warrants. We'll talk about the law prior to that, and then we'll talk about a brand new case, Minute. Let me give you the slide. We'll talk about why we changed it, why we want to get search warrants for blood and DUI cases. The new law, State versus Minute, just came out last month in August, and it's thrown a whole new monkey wrench in, and it's a good kind of monkey wrench, I think, for law enforcement and prosecutors in our attempt to get as much evidence as possible in DUI cases. We will talk about the logistics behind telephonic warrants, and that will include the law that has been around for quite a while. It's pretty antiquated. We'll talk about that, and then we'll go over the form. I am interested, for those of you who've had experience with these forms before, I am interested in your input and your comments to help everybody out when we get to that point. I am the speaker throughout today's training, so I'm going to be going back and forth between the questions that you send me and the slides, so there might be some strange pauses while I'm reading questions. Like just now, I was just catching up to make sure that I had everybody's information. If there's something in particular that you have a question about, please feel free to type me a message, or there's a little hand-raising mechanism I can try to keep an eye on. Barb also will be keeping an eye on that. If I'm cruising along and I've ignored you accidentally, I apologize. I'll try to pause at the very end, at the very least, to make sure that I've answered questions, and as well as between each slide. I do have my contact information on the last slide at the end. That will include my cell phone number. I think my email is on there. If my email is not on there, I will give that to you then. So let's go ahead and get started with, sorry, my computer's slow. There we go. Why did we change it? Well, these are pretty obvious reasons. In 2010, we had data that showed that there were more than 3,000 refusals during DUI investigations. And more of those than not were those with previous experience in DUI investigations. In other words, these are people who we've stopped and investigated before for DUIs. So what was happening is people were getting smart. They were figuring out that if they refused, we didn't have the blood or breath evidence to take to court, and their chances of winning were increased. Now, I do have several prosecutors who very much enjoy taking refusal cases to court. They say that they're shorter, and they figured out how to argue it effectively so that they're easier for my prosecutors. But back in 2010 and before that, the trend in the state was to look skeptically at a case that didn't have that evidence in it. And think of it this way. If you have evidence of blood or breath, it's very easy to prove your case because they can say whatever else they want, but then you give them the blood or breath test, and our jury pools are pretty well conditioned to understand it at least an 08 or above, and that's over the limit. Now, that's not to say we're going to win all of those cases. I know there are some strange cases out there where the juries just decide not to convict. But if we have that evidence, it's much harder for a jury to say that this person was innocent. And so when we don't have that evidence, when we look at it on the flip side, it just gives the defendant one more way to argue that they actually weren't that intoxicated. So We want the evidence is the bottom line. Not only is it persuasive to a jury, but it's also just a really good indication to us that we're doing our jobs correctly. And one of the things that we told the legislature, and I believe this to be true, is that sometimes we might even have a person who's under an 08. Whether or not they're under the influence depends on the rest of the investigation and what it tells us. But sometimes we'll have a person who's lower who might be being arrested, and that's still relevant evidence. So we have evidence that's good for the state and sometimes evidence that's bad for the state, though that has not been my experience. Since we had the law change, it looks like those who are refusing have higher BACs. So I don't think that's a surprise to many of us. What was really frustrating was that we had these DUI cases and we were spending a lot of time, law enforcement officers and prosecutors, in prepping for trial, in talking about suppression motions. And what we've seen since the law was changed and since officers have been getting blood is that the caseload has decreased. Not because they aren't pleading guilty, but because they may come in and plead not guilty, then they get their defense attorney, and then their defense attorney takes a look at the case with them, and ultimately they come in and plead before they go to trial. Now, of course, it's the defendant's decision whether or not to go to trial, but what we're finding is the caseload for trial has gone down dramatically. This means that prosecutors have more time to spend on other cases. It means that law enforcement officers have more time to get out on the streets and keep us safe. So this is good for everybody. Okay, I'm going to pause a little bit, check the questions. I have a question. Can we get a copy of the slides? The answer is yes. If you send me an email, actually I'm going to give you Barb's email right now. Barb's email is barb@inmantraining, B-A-R-B @INMAN training.com. And just send her a request and she will send you a copy of the slides. I'll make sure she has a copy of these as soon as the webinar is done. All right, that looked like the only new question. Oh, there's another new question. Oh, there was a thank you. You're welcome. All right, moving on. So we're going to talk about just the basics because, of course, when you're getting a search warrant, you have to start with the constitutions. And we have both the United States and the Montana Constitution that allow us to get search warrants. They protect us from unreasonable searches and seizures. And they say, in a sense, that search warrants are not unreasonable. They're based on probable cause. We're going to an impartial magistrate, so somebody who's not biased, and we're giving them all of our articulable facts, and they are making a determination for us that there is probable cause to proceed and get the evidence that we're seeking. So that's pretty simple stuff. I won't belabor that point. I do find that oftentimes when I'm out training, people forget what probable cause is, so I've built in to this PowerPoint just my working definition that I use, and this is based on all the cases out there. There's a probability, so not a certainty, not a greater than not chance, it's just a probability, so it's really not a huge burden. Based on facts and circumstances and the totality of the circumstances, that a reasonable person would believe a crime has been, is being, or is about to be committed. So when we're talking about the case of search warrants for blood in DUI cases, and we'll talk about the procedure a little bit later, but you will be applying for it after you've arrested them. And in most cases, there are some cases where you won't have arrested them, but in most cases you will have already arrested them. Now the standard of probable cause is the same for an arrest. So this should be a pretty easy burden to meet when you're calling the judge. The trick is going to be articulating your facts and circumstances in such a way that the judge understands them and is able to agree with you about the totality of the circumstances, leading a reasonable person to believe that a DUI has been committed. Again, it's not a huge burden. You've already met that standard because you've arrested the person for DUI. Now we're putting it into a warrant, all your facts and circumstances, and that's what the form is helpful with, is reminding you not to forget some of the more important things. And again, we'll go over that form at the very end. All right. Checking for questions. Tim Coleman. I think you're going to like the new minute case. Tim's question is, why can't we get a search warrant on first DUI? Well, let me show you. Let me see if I have the next slide. Okay, the reason is because, I'm going to jump ahead just a little bit. We're talking about 618-402 subsection 5. And prior to 2011, Tim, what that said is if the person refuses, no other tests shall be given. And what the court had said previously in several cases was that that language meant that no test, not even a warrant test, could be given. And just a little preview of what the minute case said last month. The minute case said, yeah, but that was all dicta. That wasn't on point, and so none of those cases count, so you can get warrants in all DUIs. But everybody don't get too excited yet, because we had changes in 2011 to this subsection that I'm going to talk about right now, and so now it's really up in the air whether or not we can get warrants on first offenses. Well, I wouldn't say it's up in the air, but you're going to have to talk to your county attorneys about what argument they want to make and whether they want you to pursue it yet or not. So, but what I want you to remember is, bottom line is, this all revolves around 618-402, and that is our implied consent law. And that one subsection, subsection 5, talks about the different categories of people who can get warrants. That's what it says now. And prior to 2011, it said nothing about eligible people for warrants. It just said, if they refuse, no other test shall be given. Okay? And then we had all sorts of Supreme Court cases, none that were specifically on point. So none that a prosecutor said, hey, subsection 5 is only administrative, the whole implied consent thing is only administrative, that only applies to suspending or revoking persons' licenses. It doesn't impact the criminal investigation at all. We didn't have any cases on point that said that. But what the court said in other cases that were related to DUI, they said it in just what they expanded on some of their logic, and in those cases they were tangentially related to subsection 5 and implied consent. But because none of them were on point, it's called dicta. So it's not precedent necessarily. Nonetheless, they said it so many times that everybody believed them, that that's how they would rule, and we don't violate statutes. We're in the law enforcement side, and we encourage others to follow statutes. So because we understood the court to mean that that's how they would rule, which I think is true back then, we went ahead and we didn't get warrants. We respected that language. Let's take a look at the new law. This was Senate Bill 42. This was proposed and carried by Senator Shockley in the 2011 session. Of course, he's the senator who stepped down from being head of the Senate Judiciary at the very beginning because he was stopped on his way home from Helena with an open container. So he stepped down from it, but he still sponsored this bill and pursued it. What he originally had proposed was to strike all of that language that said no other tests shall be given, so just get rid of the troublesome language altogether. There were some strange arguments about it being unconstitutional, and I would say that people who said that have never read the Constitution, because search warrants are in our Constitution, but I'm not a legislator. The other argument, and this is the one that really gained traction and is the cause of the scale back, and that argument was that if you allow them, law enforcement officers, to get search warrants in all DUIs, then that's going to have a fiscal note attached, and that means it's going to cost the state money. And the reason it's going to cost the state money is because all of those blood samples are going to be sent to our crime lab that is already slow in processing its blood, and we need to hire new toxicologists and get new instruments in order to support that new demand. So imagine from 2010, and then in 2011 we're proposing this legislation, we're talking about 3,000 new blood cases. If we were to get blood in every single refusal case in 2010, that would have been about 3,000. And that would have cost a lot of money. So what they did was they said, well, we'll let you get it in some of the more egregious offenses. So those people who have a prior DUI conviction or a pending DUI conviction or a prior refusal, those people, we agree with you, those are real problem people, and we want to make sure they don't get away with it. So we're going to let you get warrants if they refuse. And that's how we ended up with this. It was a compromise because of the fiscal note that was attached. It was a compromise to allow us to at least get blood on some of the more egregious offenders or more dangerous offenders. And this is a breakout of the language that was ultimately passed. I'll let you read through it just a little bit. And then I want you to take note and take a look and tell me if a person, let's say this is their first DUI, so you're investigating a crash and you have probable cause to believe that they're DUI, and they kill somebody or they inflict, the crash causes serious bodily injury to a person. Where in here does it allow us to get a warrant for them? And the answer is they didn't carve out an exception for that. If we were to follow this strictly, then you would not be able to get a warrant for first offense vehicular homicide or negligent vehicular assault if they didn't have a prior refusal, prior conviction, or a pending DUI offense. This has caused us to kind of train that point in a, I don't want to say creative, but we put our heads together because we certainly didn't believe that was the intention of the legislature, and we didn't believe that that was how it should be. So these three cases, a person who has a prior refusal, a prior conviction, or a pending offense, they are absolutely eligible for a search warrant for blood. Every time, no question. And what we tell people is if there's a serious bodily injury or death case that you're investigating, to go ahead and get a warrant based on probable cause after they've refused. And we do have, this is prior to the Minute case, we do have an argument that it doesn't matter that this language is here because this is all administrative anyway. That was one of the arguments. The other argument was, well, there are 45 code crimes, not 61 code crimes, and so this isn't meant to apply to the 45 code crimes. So the bottom line is, for prosecutors, we had a couple of colorable arguments that it was okay to get blood in those cases. And the risk was, if you go and you get a warrant and you get the blood and we're wrong, the risk is that we get that evidence suppressed. And that was an argument we were willing to make in those cases. So that's what we've been doing in Montana. That's how we've been training for the last, this is 2014, for the last 3 years. We have gone across the state and we've advocated getting blood whenever you can if that person has a prior refusal, a prior conviction, or a pending offense. And if it's a serious bodily injury or death case, go ahead and get a warrant, and we would argue that one in court. Okay, I'm going to pause just a little bit. I have some questions. The question is, given the increase in the case volume at the crime lab, are they increasing their staff? They have not increased their staff. They do have Doug Lansone, who works with Ben Vetter in the intoxilizer area. He cross-trained, so he also does blood analysis now too, and he did that to catch them up because they had a backlog for a while. And my understanding is that he continues to work with them because their caseload has increased so much, not just because of warrants, but also because DRE and ARIDE training has just increased the number of blood samples being given. And of course, our beloved Lewis and Clark County, who only does blood, all of those factors have almost doubled the crime lab caseload, but they're doing it with still the same number of people. My understanding last time I looked was that the Attorney General was asking for another toxicologist this year, that he did put that into his budget, but that's it. So, and that would alleviate the stress, the existing stress. But if we were to get the ability to get search warrants for first offenses, which, like I said, in Minute we may or may not already have, that would be another 2,000 cases potentially. And I don't know that that means that all 2,000 are necessarily going to be drawn. So what I'm trying to say is, just because a person refuses doesn't mean that we are ultimately getting a blood sample for them. So 100% of that 2,000 might not actually occur. But it's going to be a substantial increase for the crime lab if we start getting warrants for first offenses. But on the investigative and prosecutorial side, that's something that we just need to support the crime lab in, and the Attorney General is in getting the funding, because we need to do our job, period. So if you have to get blood, you have to get blood. If you have to get a warrant, you have to get a warrant. That's just part of your job. So we're working with the Attorney General to support him in his endeavor to get more people. Okay, I have a question. Can we consider tribal criminal records for DUI and or refusal? And the answer to that one is yes. We have another reference in our DUI laws when sentencing an individual that specifically says we can use tribal DUIs as prior offenses. So not only can you use that to qualify a person to get a warrant, but you can also note it on your citation so that if they do plead guilty, the judge knows that that individual has a prior offense and they should be sentenced accordingly. What it doesn't say in our statute is if they have a DUI from a different country, if we can count that. And so I'm talking about Canada mostly. While it does say that tribal convictions count, it does not say that Canadian convictions count. So I would still note for their record that they have a conviction in Canada, but I can't give you an answer as to whether or not they'd qualify under 61.8.402 subsection 5 for a warrant. That's one of those things where I think you have a colorable argument, but that's a finer question for your prosecutor. So next time you're having coffee with your prosecutor, ask them if a Canadian DUI qualifies them for a warrant. Okay. So this is what we've been training for the last 3 years. Let's talk. Let me finish up procedurally how this looks then. And again, this is how we've been training for the last 3 years. We haven't been wrong for the last 3 years. It just may be that now we have more opportunities for search warrants. So if you're using 402 subsection 5, first they have to refuse. So first in your process, you've arrested them for a 401 violation or a 465 violation, and now you're reading them implied consent, and now they refuse. It isn't until that point that subsection 5 is triggered. Okay, so you can't just arrest a person and go get a warrant if you're using the process outlined in 402. If you're using the process outlined in 402 procedurally, first you're getting them to refuse, or they are refusing. I guess you're not trying to get them to refuse. And then you're applying for the search warrant. Now, I always get the question, what if they say, well, if you're getting a warrant, then I'll go ahead and provide you a sample. This is just a best practice notation. This isn't necessarily the law. The best practice is just go ahead and get the warrant. As you'll see with the telephonic warrant, the time involved is not too onerous, though I do understand that for some of you, the paperwork on the back end is pretty involved. But best practice right now is until you get your entire department up and running on telephonic warrants, please don't make your prosecutor make this argument about coercion. They're going to get enough challenges. If you haven't been doing telephonic search warrants, they're going to get some stupid challenges to begin with, and we just want to eliminate the whole coercion argument. Now, if you're in a department that's been doing this for a while, you might be able to fine-tune it, but that, again, is something you need to talk to your prosecutor about. So if let's say you're in a jurisdiction, you've been doing telephonic search warrants, you've worked out all the kinks, the challenges are now gone to the telephonic warrant, and now you have an individual who says, oh, if you're getting a warrant, I'll go ahead and give you the blood. Again, best practice is to just get the warrant, but if you want to talk to your prosecutor and your prosecutor wants to make the argument, you could do that. Just be careful if you do head down that road that the language that you use when talking to the suspect is, I am applying for a search warrant, not I'm getting a search warrant, because there is a distinction. So if you are going down that road, and it's just a good habit to get into anyway, all right, I'm going to apply for a search warrant to get a sample of your blood. Okay, I'm just looking at questions. Oh, this is a good question. Golden Valley County does not have a hospital or clinic, and so it's their understanding that they can't use the process because the JP does not have jurisdiction for another county. And the district court does not like to issue warrants. Well, this session is being recorded, so everybody has me on tape. For the record, I am saying that's the district court's problem. That's not your problem, number one. You're following the right process. Your justice of the peace is the first individual you contact. You are correct. The courts of limited jurisdiction have interpreted the law to mean that if an individual is outside of your county when you're applying for the warrant, they do not have jurisdiction. But the county that they are in does have jurisdiction. So let's say that I'm in Jefferson County. Now, Jefferson County does have the facilities, but I'm in Jefferson County, and it's right up against Lewis and Clark County. Let's say, for whatever reason, the individual ends up in Lewis and Clark County. And this happens all the time. There might be a crash on the north end of Jefferson County, and they've been taken to the hospital, or they are leaving the hospital after having gone to be checked out, and you're going to arrest them in Lewis and Clark County. Well, now the Justice of the Peace in Lewis and Clark County has jurisdiction, so you can apply to that Justice of the Peace. It would not be proper in that case to apply to the Justice of the Peace in Jefferson County. You want to apply where the blood is being drawn, where the individual is. Okay? So that's number one as far as Justices of the Peace. Similarly, city courts, if you're just staying within the city, a city court judge or a municipal court judge may have jurisdiction, but their jurisdiction is confined to just that. On the other hand, district court judges have jurisdiction statewide. And there are several cases dating back, I would say 10, 15 years ago. There's one out of Billings, I'm sorry I don't remember the site, where a Billings law enforcement officer sought to obtain a warrant, but the district court judges weren't up late at night. So this was like at 2 o'clock in the morning. And it became well known that the judges were just unavailable at dark 100. And so rather than applying for a warrant because they couldn't get one because there were no district court judges available in their jurisdiction, they went ahead and claimed they had exigent circumstances and therefore they could search, I don't remember if it was a car or an individual or a house. So they used the exigent circumstances exception. Our Supreme Court said, nope, you have to get a warrant. Exigent circumstances doesn't apply just because a district court judge isn't available. And then the Supreme Court said, it's the district court judge's job to be available. So some of your jurisdictions, I know, don't have multiple district court judges, and they do get to sleep and they do go on vacation. But if your district court judge, for whatever reason, isn't available, again, not your problem, you call another district court judge anywhere in the state. So you just start going down your district court judges lists until you find one that's available. And when you finally do find one that's available, you tell them that you're applying for a telephonic warrant. And if they ask why you're calling them, you can just let them know, I tried calling this district court judge, I tried calling this district court judge, and they weren't available. Okay? It is not your problem if a district court judge is not available. You just move on to the next district court judge until you find someone who is available so that you can get your warrant. And then we'll let the district court judges sort it out amongst themselves in whatever way they desire. So I hope that answers your question. All right. Anytime you take blood, and this is the Schaaf case, State versus SCHAUF, anytime you take blood from a person, you need to let them know they have a right to an independent blood test. And this language is contained in your implied consent advisory. What happened in Schaaf was there was a person a DUI person had crashed into another person and killed somebody. And so the DUI lady was at the hospital, and the trooper responded and was investigating her, and she was screaming at him the whole time and rude and belligerent, and it was very clear to him that she was not going to sit still and listen to implied consent, let alone give him consent. So he called his county attorney and asked, what should I do? And the county attorney said, get blood. And so he did. Well, the issue in the case was that that blood sample, that individual had not been given notice. So she had not been read the implied consent advisory. She had not been given notice specifically to the fact that she had a right to an independent blood test. And the Supreme Court said that that was a due process violation. You have to give her notice that she has a right to an independent blood draw if you're going to take her blood. Now, in light of Minute, the case I'm going to talk about here in a minute, no pun intended, in the Minute case, it seems to separate administrative law from criminal law, so I don't know at this point if Schaaf means that only when it comes to implied consent draws do you have to give them notice that they have a right to an independent blood test, or any time you're taking blood from any individual in a criminal case, do you have to let them know they have a right to an independent blood test? I don't know the answer to that. What I tell everybody is, I really don't care. Just tell them they have a right to an independent blood test if they want. And if you have the ability, if they want it and you have the ability to facilitate that, you have the time in your schedule, a policy in place that allows you to take them to the hospital or whatever it is, then go ahead and do it. Make a note. Let the hospital know that we'll be seeking a warrant to get the blood so we can sample it ourselves, and or that we're going to be subpoenaing those records, because their blood sample is going to turn out the same as ours. It's not like we're Wizard of Ozing behind the curtain, the blood result samples. So more evidence is better. If they want to get an independent blood test, more power to them if you have the ability and if they have the ability to pay for it. That's just going to be more evidence for our case. All right, I think that's it. Do I have any more questions on what we've talked about so far? Okay, here's the Minute case I've been talking about. Everybody should write this citation down and take time to read it. Oh, there's a question. Oh, no, it wasn't a question. It was a, oh, there is a question. What happened? Oh, okay. What happens if the nursing staff refuses to draw the blood because the defendant is being violent after you have the warrant? Okay, that's a good question. In obtaining blood evidence after you have a warrant, you are allowed to use all reasonable and necessary force. So this is just like any other search that you conduct. All reasonable and necessary force. And so I would look to your policy and procedure for your department to determine what that is. My recommendation is that your jurisdiction has a restraint chair for DUIs. It looks like a dolly, and it has a chair and straps attached to it, and I think it costs less than $500. So that's my recommendation, is that you have one of those at the hospital, and that you, law enforcement officer, put the person in that and strap them down so that the nursing staff doesn't have to deal with a violent person to help us out with our cases. That's ideal. you to do it as long as you're supervised by a doctor and you don't have to have the doctor looking over your shoulder. But you're going to want to take some cautionary steps when doing that. Okay. All right, so state versus minute. This just came out in August. And this was an arrest that occurred under the 2009 law. So this is that law I was talking about that said if they refuse, no other tests shall be given. This was prior to the changes in 2011. Okay? And what happened here, this is down in Butte, was a bad guy. He was fourth offense DUI this evening when he crashed and caused serious bodily injury to another person. So they were looking at him for negligent vehicular assault. They read him implied consent and he refused. Well, again, this is the old law that didn't have all those exceptions built in that said if they have a prior, then you can go ahead and get a warrant. But this is a felony level 45 code crime, and so they were using the logic that 45 code crimes should be treated differently than 61 code crimes. Remember how I told you that there are colorable arguments for prosecutors to go ahead and authorize law enforcement getting search warrants for these felony level cases causing serious bodily injury or death. That's the argument that they had adopted in their jurisdiction. So sure enough, they got a search warrant. They got his blood. It was relevant. It was used against him. He fought to suppress it, and this went all the way to the Supreme Court. And the question at the Supreme Court was, should it be suppressed or not? What our Supreme Court said, and again, this just came out in August, what our Supreme Court said was 61.8.402 is an administrative process. Anybody who's ever been to one of my classes where I teach implied consent, I talk about law enforcement taking off their criminal justice hat and putting on a different colored hat entirely. So this is your yellow hat is what I usually say. And now you're working for the Department of Justice Motor Vehicles Division Licensing Bureau. They have that 61.8.402 law that says we can just yank their license if they refuse. Number one, if they're in a condition that leads us to believe that they're DUI and they're under arrest, then you've already impliedly consented to give the blood. But if you refuse, we get to yank your license. So that has nothing to do with the criminal case. That's just all administrative procedure. And what several states have said is the administrative procedure is separate from the criminal procedure, and it doesn't necessarily preclude an officer from being able to get blood. And that's what our court said. They said all those other cases that we alluded to the fact that that language said you can't get blood even by a warrant, well, all of that was dicta. None of it was precedent, and therefore you can get blood in DUI cases under the language that we used to have. Okay? Is everybody tracking so far? Type me a question if you have a question about that part of it. I'll pause for just a second. Okay, I don't see any questions. If I see one come up, I'll go ahead and go back. Okay, so now the question is, we changed our laws. What does the impact of our 2011 changes have on minute? So just because we changed it, does that mean that now it's a criminal statute and not purely administrative, and therefore it rules everything and we have to follow 402? Or is it still purely administrative and it doesn't matter what they put in there about criminal stuff? Now we can get warrants in all DUIs? I don't know the answer to that, but what I do know is that when you read 61.8.402 closely, it only applies, it's only triggered in certain cases. If a person's under arrest for 61.8.401 violation, it applies. If they're under arrest for a 61.8.465, so that's aggravated DUI violation, then it's triggered. If they are involved in a crash involving serious bodily injury or death, irrespective of whether or not you have probable cause of a DUI. So there's a serious bodily injury or death, implied consent applies because this is a licensing provision. This is an administrative law. If a person is under arrest for a 410 violation, then implied consent is triggered. Now, my understanding is that you don't arrest people for 410 violations, so I don't know that that ever actually happens, but that's just something for you to think about. What is not included is if you arrest a person for a 61.8.406 violation. So if you've arrested a person, if you have probable cause to believe and you've decided to arrest them for a per se, an 08 violation, then implied consent isn't even triggered. And so there's no prohibition on you being able to get a warrant. Talk to your county attorney. Please don't start doing this until you talk to your county attorney. You're going to want to brief your judges ahead of time, let them know this is coming, because you don't want to wake them up in the middle of the night and say, hey, I went to a webinar and I spent 3 hours reading the minute case and I figured out I could get warrants, and so now you need to catch up with me. This is something that you need to talk to your county attorney about. The judges need to be made aware of so that people are educated about it before it happens. Minute does say it's administrative and it's separate from the criminal process. So if it's not even triggered, I don't know what argument a suspect would have that would prohibit you from being able to get a warrant if you're arresting them for 406. Now the question I always get when it comes to that is, well, how do I have probable cause that they're above an 08 if they're refusing everything? Remember, probable cause is just a probability. And law enforcement officers, you've been trained on SFSTs, and if they score a certain number on the SFSTs, then they're probably above an 08. So you have that, number one. Those of you who've arrested several DUIs typically know when they're above an 08, and it's based on your training and your experience and your articulable facts. That's your probable cause. And here's the other way to think about it. When you're applying for a search warrant to get, let's say you're investigating a homicide and you have probable cause to believe that a murder weapon is in a house. So you go and you apply for a warrant based on your probable cause. You don't know exactly where the weapon is. You don't even know if for a certainty that the weapon is in the house. There's just a probability based on all the articulable facts that that murder weapon is in a particular house. You don't need a certainty. I'm confident that a 406 violation first offense you can get a warrant for. I don't know if the court means to say that now that we have those 2011 changes, you can only get warrants once implied consent is triggered under those situations that I told you about before. I don't know if our argument about it being a 45 code crime for serious bodily injury or death cases still apply. I don't know if the court will ultimately say 61.8.402 is purely administrative and criminal law applies to all crimes. I don't know that. That's stuff that you guys get to sort out, and I'll look forward to hearing how it does turn out. All right. Any questions on that? That's quite a lot of information. Bottom line is, I encourage you to read Minute. And if you want to sit down with your prosecutor and you'd like me to talk to them with you on conference call, I'm happy to discuss that with them. Okay. Moving on. All right, we're going to leave the land of who qualifies for a warrant and when can you get a warrant to the process involved in getting a telephonic warrant. Now, Montana has had a telephonic warrant law for many, 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 many years. And prior to 2011, when our warrants for DUIs were clearly changed, the laws were changed, the people who really used this were our interdiction folks. So those who were roadside, they had a car stopped and they wanted to be able to search the car. That exists that justifies immediate issuance. So there's some reason why you're not able to, or it would be inappropriate or impractical for you to be able to go to the judge's house or the judge's office with a paper warrant that you've typed up and filled out and signed application, and the judge signs it, and then you go back and search. And this is why those interdiction law enforcement officers were the ones who used it, because it's just not practical roadside when you just want to search the car and let these people go on their way if there's nothing in it. The same logic applies in these DUI cases. The evidence of the alcohol concentration or drug concentration in the blood is changing. It might be going up, it might be going down, we don't know. We have probable cause to know that while they were driving, they were under the influence. We have probable cause to believe it's still in their system. Evidence of that drug or alcohol is still in their system. And we know it's changing, and we want to get the best evidence possible in as close a time to the actual driving event as we can. And that requires immediate issuance. If we have to spend a couple hours running to a judge's house, it's going to be farther away from the driving, and that's not ideal. You certainly could do it, and I know there are jurisdictions where they're doing paper warrants still, but telephonic warrants are designed to be more immediate in nature. Now, the language in Title 46 with regard to telephonic warrants is a dinosaur. It talks about recordings, and it talks about, I'll go all the way to the bottom, putting the actual recording in the court records. So it contemplates a tape recorder. Then you pop the little tape out and you put the tape in the court records, or you keep a copy in evidence. And most law enforcement officers use digital recordings now. So we don't have a problem with that second requirement, that it's electronically recorded, and you do have to capture both sides of the conversation. So you want your words and the judge's words to be captured. Okay? Somebody has to record that. Once it's recorded, it's ultimately going to have to be transcribed. Now, you're going to see at the end we have forms and templates, and those forms and templates are designed to help you say the words that you need to say and get you prepared to apply for the warrant. But your application, your actual affidavit in applying for the warrant, are the words that you speak. Your application is not that form that you fill out. Your application are the words that you actually say to the judge on the phone and that are recorded. And that's why they're having you transcribe it. I know that for many people who have been doing this for a while, that transcription can get frustrating. Some law enforcement officers do the transcription. Some of you have assistants who do it. Some of you, the judge actually does the recordings, and the judge has somebody who transcribes it. All of those are allowed. But the law enforcement officer's office and their offices who are having to transcribe it, I understand that it's a time-consuming process to actually transcribe, and it's especially frustrating when the case isn't contested. Nonetheless, it has to be done just because Title 46 says so. And then finally, the recording must be retained in court records. What I recommend, because we don't actually have tapes that we pop out of tape recorders anymore, is that however you're retaining that copy in court records, whether it's a CD or some other means, in your report in the case file, make sure you note how you're doing it. So if you're making a copy off of your digital recorder, or if you're making a copy off of the computer, whatever it is that you do, note that in your report for the case file, please, in case it becomes an issue. Those prosecutors who I have on the webinar, I don't think that that'll cause you problems. If you ever get challenged on something, just remember that it has to go to substance, not form. If we're just talking about the process, the form in which things are done, then the correct remedy is not to suppress the evidence. It might be just to correct the process for future workings. So just keep that in mind. That goes to form, not substance, and it's only the substance of the warrant that should cause a suppression. Okay, any questions about that? I think I have one more slide. I talked a little bit about this. You should decide who's recording the conversation. So law enforcement officers, you can certainly use your handheld digital recorder. If you have a cell phone that records, that's a great way to do it. If your judge wants to be the person recording, that's fantastic too. Similarly, you should know who's responsible for transcribing so that everybody knows the next day or the next time you come on shift that that's your responsibility or somebody else's responsibility. Some jurisdictions, you have to figure out if the judges want to go on call. I know in Lewis and Clark County, they have a rotating phone for judges, and the judges will take turns being on call for issues such as warrants. And that's a nice way to do it. So now the judges have arranged to have evenings off. In Billings, the way they do it is they just put the judges on a rotating list. And if another judge got the phone call last time, it's a different judge's turn this time to get the phone call. So however you want to work it out in your jurisdiction is up to you and the judges. Who's on call, or just call me every time. Whatever it is that you want to do, that's fine. Just remember, if for whatever reason you can't get a hold of your justice of the peace or your district court judge, you can start calling all the other district court judges in the state. And you can tell them, I'm the one who told you to do that. That way you won't get in trouble. I will. Okay. My last question, does a prosecutor have to review the application? So you're applying for your search warrant that night. Do you need to get permission from your prosecutor before you call the judge? No, you don't have to. What I do recommend is if you haven't been doing this process historically, that you go to your county attorney or your prosecutor and you say, we're going to start doing this, and I would like your input. Is this form what you like? Lewis and Clark County has their own form because they wanted it in a different format and they wanted a couple things different. So whatever your prosecutor, remember they're the ones who have to argue to uphold the warrant in court. So you want to work with them to make sure that you're getting them what they need in order to do their job. So if you haven't been doing this historically, please go meet with your prosecutor and go over the whole process. Again, if you have questions, I am happy to answer them. Just have them give me a call, and I can either talk to them one-on-one or we can conference call. Okay, I don't have my email on there. I'll leave this up for a little bit before I go to the actual form. I see I have about 5 minutes left, so I'm just going to spend 5 minutes showing you how to get to the template, telling you how we came about it, etc., etc. If you really want to get a hold of me, texting me is actually the best. Calling me on my cell phone is the second best way to get a hold of me. You can call me repeatedly. I don't mind. You're not going to offend me. And the worst way to get a hold of me is email. But if you must email, go for it. Just know that I won't get back to you right away. Okay. I'm going to... There's the warrant. Let me first show you where this is. If you go to www.mdt.mt.gov/TSRP, and actually let me start there. That is the web page that has some good information on it. You scroll down to Forms and click on Forms over on the right-hand side, and there's the telephonic warrant. Click on telephonic warrant. You can download this to your office, to your work computer, whatever you need to do. This is a fillable form. So this is an affidavit, and it walks you through all the steps. So turn on the recording device, read verbatim the following document, including the necessary filling areas. So what you're going to do is you're going to fill in everything. You can either print this and handwrite it, or you can fill it in on your computer. You fill out the entire form before you even call the judge. Then you call the judge and you read through it just as it says. You'll notice up here, it's the prompt to turn on your recording device. You have some preliminary information here. Thank you, Your Honor. I will now continue with the affidavit. Okay, so under this black line is where the affidavit actually begins. And remember, it's the words you say, not the words that you write, that are the affidavit. Now, if you are a tech-savvy person, you'll like this form because, you see, I just typed in my name. I'll hit enter. Once I fill in my space, this is Officer Aaron Inman, you'll notice that throughout the form, it automatically populates my name. So for the affidavit, it has Aaron Inman. In the search warrant itself, it says Aaron Inman. In the service of search warrant, it says it. And in the return. Okay, so this is designed to help you take as little time as possible. Again, there's nothing wrong with handwriting if that's what you prefer. But if you like computers and you're writing it on the computer, it sure makes it easy. Now these boxes that you check, you'll notice that we don't have absolutely every possible option for you. So there might be facts in your DUI that are significant to support probable cause. Maybe the individual threw up on themselves or something like that. There are some small spaces to put that in, but this is designed, it's a whole of 2 pages, the affidavit portion, just 2 pages. And the idea is you're seeking immediate issuance. So you don't want to have a 30-minute conversation with the judge about all the minute details of the case. You just want to give the judge enough information to support your probable cause so that they can go ahead, issue the warrant, go back to sleep, and you can get on with your job. Okay, so that's what was in mind when we designed this form. This form is actually based off of Arizona's telephonic warrant affidavit and warrant. Arizona's been doing telephonic warrants for years and years and years. They are also in the Ninth Circuit, the United States Supreme Court, which we are in, and so we decided that that was the best model. David Carter, he's now Judge Carter in Billings, was the Deputy Yellowstone County Attorney who modified the form for Montana purposes, and the Montana Department of Transportation made it fillable for us. Again, you don't have to use this form. It's just a really nice way to do it. I'm not going to spend any more time than that on it, mostly because we're out of time. But if you have specific questions about the form and the process, please do get a hold of me. And if I can't answer the question, I can get a hold of somebody who can answer the question. So I am trying to figure out now how to see the questions. There they are. That's all the information I have. So I'm going to go over, I see I have a couple questions. Will it fill in, yes. So if you put the suspect's name, the question is, will it fill in the suspect's name on the form? So if you fill in the suspect's name, yes, it should auto-populate everywhere it has the suspect's name also. And does it include search warrant and return and other paperwork? Tim, I hope I answered that question when I scrolled down. I think that's what you were asking. Let me double check though. Let me show you again. So you have the first 2 pages, sorry everybody, first 2 pages are the affidavit. So waking up the judge, telling him to get ready, starting the recording device, and all of this is the affidavit portion. Okay? And then at the end you're saying to the judge, I will provide a recording of this to your chambers as soon as possible. And I'll also place a recording of this into evidence. Okay? Then you have the warrant itself on the 3rd page, and the service down at the bottom of it, and the keeper's receipt. Okay, all one piece of paper. And on the 4th page is the return. Okay, and you can, I have the original Adobe version of this. So if you want the original Adobe version, I can certainly send it to you so that you can change things to the there's the order of custody, to the liking of your administrator and your county attorney and your judge, because I understand your jurisdiction might be a little different. I have another question. Do I have any other dates for another webinar? And the answer is I don't have any dates right now. My contract with the Montana Department of Transportation ends on Tuesday. They don't have a new RFP out for TSRP services, so there is going to be a gap in services. I don't expect it to be up and running again until sometime in 2015. So what that means is, yes, I'm still going to be working and training, but my trainings are no longer provided at no cost. And certainly one of the things I'd like to do is to have webinars, because I know those are affordable for everybody and easy. So I do have some ideas on webinars, and I am planning on doing that. I just have to wait until Wednesday to figure out exactly how I'm going about doing that. I will make sure I keep you on my email lists, and I'll send you out my training schedule as soon as I know what that is. Can we see the webinar again since it's recorded? I think so. You know what I'm going to ask you to do? If you'd like a copy of this webinar, if you could email Barb at inmantraining.com. I'll ask her to go ahead and put it on a DVD for you. She's going to have to give it to me, and I'll probably put it on a DVD for you, but we'll burn it somehow and make that available for you. Or the other thing that I might do when I get my business web page up and running is I might make it accessible to you there. So I'll figure out some way to get it to you. All right, if you have any other questions, please feel free to text me, call me, email me, whatever you need to do. Thank you for joining us today, and I look forward to working with everybody in the future. Bye-bye.